The air in courtroom 4B was thick. Stale coffee, cheap suits, and rising panic. Every seat was filled. Journalists hunched over notepads, lawyers shuffling papers, union workers and corporate types eyeing each other warily. All eyes were on Arthur Finch, a mid-level executive sweating on the witness stand. The central question: can you secretly record someone and use that recording against them? The law was a patchwork. One-party consent in some states, all-party in others. Arthur Finch, with his collection of cassette tapes, was about to find out which rule applied. The room held its breath, waiting for the judge. This wasn't just about Finch. It was about technology outpacing the law. Tiny tape recorders meant any conversation could be captured, any private moment replayed. Was your boss recording you? Your neighbor? Trust itself was on trial. Judge Julian Hayes, known for no-nonsense rulings, surveyed the tense room. He saw the reporters, the union men, the corporate lawyers, each with something at stake. This was more than a case. It could define the law for a generation. The silence was heavy, the kind that comes before a storm. Everyone waited for the gavel to fall, knowing the answer would ripple far beyond these walls. The stakes: privacy, trust, and the rules of a new technological era. Finch's tapes were more than evidence. They were a test of the boundaries of privacy. The courtroom was a powder keg, and the fuse was lit. The judge's decision would echo far beyond this day. The silence stretched, anticipation mounting. The storm was about to break. The 1970s redefined privacy in America. Watergate made secret recordings infamous, and suddenly, anyone could buy a pocket-sized tape recorder. These devices, marketed for students and businessmen, quickly became tools for clandestine eavesdropping. The law lagged behind, creating confusion and paranoia. One-party consent let you record your own conversations in some states. In others, everyone had to agree. Supporters called it a shield for the powerless. Critics called it a dagger to trust. The lack of a federal standard meant chaos. What was legal in one state could be a crime in another. Businesses and individuals alike began recording everything, flooding courts with disputes over admissibility. Judges faced tough choices, with little precedent to guide them. The nation was forced to ask, where does the right to record end and the right to privacy begin? Arthur Finch's tapes would soon become the flashpoint for this debate. The country watched, waiting for a new line to be drawn. United Workers' Union versus Sterling Manufacturing started as a bitter labor dispute. Negotiations dragged on, accusations flew, and trust evaporated. Arthur Finch, VP of HR, secretly recorded 3 negotiation sessions, convinced he was exposing union duplicity. Sterling's lawyers saw the tapes as a silver bullet, relying on the state's one-party consent law. The union's attorney, Maria Flores, was outraged, calling the recordings a violation of privacy and a threat to honest negotiation. The legal battle shifted, not just about wages, but about whether secret recordings could be used as evidence. The courtroom became a battleground for the future of privacy. The tapes were more than evidence. They were a symbol of a changing era. Both sides prepared for a showdown that would set a precedent. The stakes were no longer just about a contract, but about the rules of trust in modern America. The judge's ruling would decide if technology could trump privacy. The nation waited for the verdict. The day the tapes were to be played, tension snapped. Maria Flores thundered. Admitting these tapes would sanction corporate espionage and destroy trust in negotiations. Union members nodded, the gallery buzzing with anger. Sterling's lawyer, Robert Davies, countered. The law is clear. One-party consent makes these tapes legal evidence. The debate grew heated, language sharp, the room on edge. Davies, theatrically holding up a cassette, declared, "This tape will show who's been lying." The gallery erupted, shouts, accusations, chaos. Flores objected, calling the proceedings a circus. The courtroom's decorum shattered. The judge's face hardened. The shouting escalated, union members and lawyers trading barbs. The judge's authority was on the line. The case had become a spectacle, the law nearly lost in the uproar. All eyes turned to Judge Hayes for order. The moment demanded a decisive response. The fate of the tapes and the rules of privacy hung in the balance. The courtroom exploded into chaos. Union workers shouting, reporters scrambling, the scene devolving into a shouting match. Judge Hayes slammed his gavel, demanding order. "This is a court of law, not a circus," he roared, silencing the room. Spotting a journalist recording, he ordered all devices confiscated, phones, recorders, everything. Bailiffs swept the room, collecting electronics as stunned onlookers complied. The judge declared the hearing in recess and cleared the gallery. When court resumed, it would be behind closed doors. The public's privilege to witness was revoked. The message was clear. Technology would not dictate the rules of justice here. The courtroom was reset, stripped of distractions. The case had changed. Privacy, not just evidence, was now on trial. The silence that followed was absolute. The next act would play out in private, but its impact would be public. The next day, the courtroom was empty except for lawyers, clients, and staff. Judge Hayes, resolute, delivered his ruling. The question: are secret tapes admissible as evidence? He declared the one-party consent law was meant for criminal acts, not civil disputes. Allowing such recordings would destroy trust in negotiations and make every conversation a potential trap. The tapes were ruled inadmissible. Hayes went further. Any secret recording for civil advantage was an abuse of the law and an affront to justice. The decision was sweeping, banning the practice in all future civil cases in his jurisdiction. The lawyers sat stunned. Finch shrank in his seat. The ruling set a powerful new precedent. The courtroom was silent, but the impact was immediate. Privacy had won a major victory. The legal landscape had shifted overnight. Judge Hayes's ruling made national headlines. Legal scholars and pundits debated its implications. Though binding only locally, its logic was undeniable. Other judges began citing the Sterling case, excluding secret recordings in civil disputes. Legislatures took notice, drafting stricter consent laws. Privacy advocates gained new momentum. Businesses scrambled to update policies, warning against secret recordings. The ruling reframed the debate, not just about truth, but about trust and civility. Boardrooms and break rooms across America reconsidered what was ethical. The case drew a bright line. Winning wasn't worth destroying trust. The ripple effect was clear. Privacy was now a national conversation. The Sterling case became a touchstone for modern privacy law. The rules of engagement had changed. The Sterling case became a cornerstone of privacy law. Judge Hayes's precedent, adopted nationwide, changed how Americans viewed private conversations. Employees, business partners, and professionals could now speak candidly, free from fear of secret recordings. The ruling didn't end all recordings. Law enforcement and criminal cases were exceptions. But it drew a crucial line: recording as a shield was allowed, as a sword, forbidden. The expectation of privacy became the norm. The burden shifted to the recorder to justify their actions. It was a paradigm shift in law and culture. The chaos of one courtroom had sparked a new era. Privacy was no longer an afterthought. It was a right, fiercely defended. The foundation for modern privacy had been laid. Today, recording devices are everywhere. Phones, speakers, doorbells. The conflict from the Sterling case is more relevant than ever. The power to record versus the right to privacy. The lesson isn't that technology is bad, but that its use matters. Arthur Finch's story warns against using tech to undermine trust. Maria Flores's outburst was a demand for dignity and fairness. Judge Hayes drew a line, affirming that law must protect civility and trust. The echo of that gavel reminds us, privacy is not automatic. It's a right won through struggle and must be defended. Every conversation carries the legacy of that courtroom. The silence of privacy is precious, cemented by the loudest moment in a courtroom that refused to become a circus. As technology evolves, the fight for privacy continues. The story of Sterling Manufacturing is a reminder: trust is the foundation of society, and sometimes it takes a shout to protect it.